These are part-heard appeals in the matters of Malik and others, and Malik and another. Yes, Mr. Malik.
My ladies, my lord, today then we have Iftikhar's appeal, which is, as you know, a second appeal to restore the first instance decision of His Honour Judge Gerald, the trial judge, and find that had a good adverse possession defence in the 2017 claim. There are two broad parts to the appeal. There's a set of points about the law of adverse possession, and specifically the possessory intent part of it, the animus possidendi. And there's a set of points about whether Vacar should have been prevented from running the adverse possession defence in light of what had transpired before Mr. Jarvis in 2011, which could be characterised as abuse of process or approbate reprobate or a form of judicial estoppel. And the correct label is, I suppose, one of the things that may be of interest.
Just before you get started,
Yes.
Have you discussed how you're going to divide up the time? I think it's important that we...
Except to say we should have the equal amount of time. We haven't been more specific than that.
Yeah.
My aspiration is to taking yesterday as the model, perhaps imprudently, given where we ended up, is to sit down at lunchtime.
Right.
And my own friend, that's how the time, we started with the aspiration we'd have equal time across both days. So if today ends up as a template of yesterday, on the
Very
template
well.
of yesterday, we'd be fine. I suppose yesterday we did presume on the court for, we sat 5 or 10 minutes late at the end.
No,
so,
that doesn't matter at all. I'm just anxious that each of you get your fair share.
if I find myself in peril of not sitting down at lunchtime, then I will begin hurrying dramatically in the latter part of my submissions. But
Yes.
I hope
Well, I
we
might
get
even
there.
give you a nudge.
Well, I'll be very grateful for it. What I propose to do
Yes.
is take the abuse point first before the
Yeah.
other possession points, because it's in one sense logically prior, and it's also more closely connected to the issues that you were hearing yesterday. So it's a natural follow-on, or at least it seems so to me, it seems so to us. So the abuse of process points, the heart of this, of course, is the relevant part of the decision of Mr. Jarvis. We went to that a lot yesterday, and I won't ask you to turn up the same passages again, but you will remember paragraph 130, in which it is absolutely clear that that decision is premised on an understanding which Mr. Jarvis thinks he has got from Iftikhar, and clear after confirmation, I'm so sorry, from Vacar, and after confirmation from Vacar, that an adverse possession defence would not be run in fresh proceedings, and therefore fresh proceedings could be started without prejudice suffered by Iftikhar. Now, when one looks at that, my starting point, and one then looks at the fact that an adverse possession defence was then advanced by Vacar in the 2017 claim, an outside person looking at that, the layperson, would think something here has gone wrong in the administration of justice in what has happened here. It's just an obvious contradiction. And all the more so if that adverse possession defence in the 2017 claim is then permitted to succeed. And my start point is that such a result would be one which involved a plain failure in the administration of justice and bring the process of the court, to use the phrase that's sometimes used in the authorities' questions, to bring the end result into disrepute. A layperson looking at it would say, hang on, what's happened here? That can't be right. It's an obvious injustice. I'm going to start with what's said in terms of, that's the start point, that's the broad proposition. Getting into the detail, the next place to go is the findings of His Honour Judge Gerald, who was the trial judge in relation to this. And I know you will have read it or looked at it, but I'm going to go through it, if I may, picking out a few points. This is Core Bundle 2, tab 17. I was going to stop at first at paragraph 8 on page 225, where the judge is dealing with this in his factual account of the history of the case. He says what happened. He said the Vacar was there. He said that any interest in the flat had been vested in the trustee who was represented by counsel. That's all right.
Sorry, which paragraph?
I'm so sorry, in paragraph 8.
Thank you.
And then in the second sentence, he says, during the course of that hearing, Vacar stated that he would not be pursuing any claim for adverse possession of the flat. He and his wife, Sarah, having lodged such an application with the Land Registry on 20th of July 2000, which he withdrew on 27th of February 2001. As the Land Registry stated that it needed a resolution by the court. So Vacar stated that he would not be pursuing any claim for adverse possession of the flat. That, in my submission, is a factual finding, reflecting factual findings made further throughout the judgment. It should be accepted as such. One then gets to the detailed treatment of this topic at paragraph 75 on page 237.
But is that a fact finding? At 8, he's just reciting what he thinks happened before John Jarvis, isn't he? He says during the course of that hearing, being the hearing before Mr. Jarvis. So
it is a finding consistent with his findings further
Okay.
that we come to as to what happened during that hearing before Mr. Jarvis.
okay, but at that stage, he's just reciting what is his impression of what's said in John Jarvis's judgment at 1:30, presumably, rather than it being a true finding of fact at that stage.
He hasn't yet come to the detail of
No.
it, but he's writing the judgment at one time. So when he writes that
Okay.
there without
Okay.
cavil and without caveat, he says that's what happened. That
Okay.
reflects the fact that he's, in my submission, concluded that that is what happened.
Okay.
One gets to the detailed treatment then, beginning on paragraph 75. He recites Iftikhar's case, that it was abuse, and introduces the point. Paragraph 76 to 79, he goes through the law. He cites various authorities, most of which at least we'll be looking at briefly later. He speaks to Bradford and Bingley and Seddon, so inconsistency, maybe an abuse depending on the circumstances. He goes to express newspapers, the approbate-reprobate case. He goes to a representative claimants in MGN, which is another approbate-reprobate case. And then he comes to a landing in 79 with a final citation, which is Mr. Justice Falk earlier in these proceedings, where she summarised the principle as ultimately being one of abuse of process. Whereas in other abuse of process situations, what the court ultimately has to do is, by an intense focus on the facts, determine whether in broad terms the proceedings fall one way or another in the broad rubric of unfairness, bringing the administration of justice into disrepute. So that ultimately is what he considers the ultimate decision he will be making, is the broad abuse of process judgment. Paragraph 80 begins his review then of the evidence relevant to this topic. And you'll see in 80 that the view of His Honour Judge Gerald as the trial judge, as the finder of fact, having heard all the evidence and the argument, was that you had to look at what Vacar was saying to Mr. Jarvis, you had to examine that in the context of what his position had been over the previous year in his dealings with his trustee in bankruptcy, which would tell you, of course, both about his motivations and what he was seeking to do, and also about the way in which he'd been putting forward the position prior to the hearing, which would have been reflected in his correspondence and the other things that would have been understood by all the parties in front of Mr. Jarvis. And in particular, you also see there that he again characterised it as a reassurance to the deputy judge that no adverse possession claim would be made if the 1987 claims were struck out. Again, I say that reflects a factual finding which runs through. It's the same one. That is what he thinks that reassurance was given. he says that it's given 1 year after Vacar had emphatically told his trustee in bankruptcy he had no interest in the flat because it was owned by his father, which is one of the striking twists and turns in Vacar's case over the years. Obviously, it was a very prominent twist and turn at that particular point, as Vacar has sought to match his case to the expediency of the moment. And you see at the bottom that the judge's further reasoning that before considering what was said to Jarvis, you need to look at that context. And before considering the said to the trustee, you need to look at the context. And you need to consider Vacar's evidence as a whole. And it's relevant that he is someone who is adept at saying one thing but meaning another, or rusticating sufficiently to satisfy the questioner, but avoiding giving simple, straightforward answers. Now, that's sometimes described as being about his character. That tag of assessment of character has been used quite a lot in submissions. It's not just about his character. It's about what you make of, how you assess statements that he makes, both as to what his intention would have been when making those statements, and as to objectively what the statements would have meant, and as to how they would have been understood by someone in the position of Mr. Jarvis, in the same position as the questioner the judge talks to here, who is receiving these statements from someone who is adept at making manipulative statements, which give an impression while being evasive, give a clear impression while being evasive. And in my submission, as long as Judge General had heard the evidence, he was the finder of facts, and he was well within his rights to take the view that findings as to what had passed between Vacar and Mr. Jarvis, both as to Vacar's intent and as to what Vacar in fact succeeded in conveying, were properly informed by wider evidence as to Vacar's motivations and Vacar's modus operandi, both of which were things the judge was very familiar with, having indeed heard his evidence. 81 to 88 then go through the detail of what was in fact understood and what in fact passed between the parties between 1987 and 2010 or thereabouts. We went to that in quite a lot of detail yesterday. I know you're familiar with it. I'm not trying to go through that now. It's there because it, as well as being relevant for the license point, it forms the context for what comes next. 89 then to 91 deal with what Vacar had been saying to his trustee in bankruptcy over the year preceding the hearing before Mr. Jarvis. And you see that in 89 and in the first sentence of 90, it deals with Vacar having told the trustee that he, Vacar, had no interest in the flat because it belonged to Bilal. So that was the line throughout this period that Vacar was pushing. I've got no interest in the flat, it belongs to Bilal. Obviously, because if he had interest in the flat, it would go to the trustee, which would have been contrary to his interests. And you see the also the judge's finding there that it was disingenuous and knowingly disingenuous, 89. Then in the balance of 90 and in 91, it goes on to deal with what Vacar was saying to the trustee about adverse possession. And the gist of that is that he was telling the trustee, as well as saying, well, the flat belongs to Bilal, and don't worry, because I don't have an adverse possession claim. And Vacar, as the judge explains here, is explaining away to the trustee why the application had been made to the land registry. The whole gist of what Vacar is saying to the trustee is, don't worry, I don't have an adverse possession claim either. The reason why this is what Vacar said in his letter to the trustee, the judge quotes here, the reason we were advised to file the adverse possession proceedings was to ensure that if Iftikhar would comply with the father's decision, he'd been in defiance, his attitude toward the family were not friendly. In other words, this is the judge recounting what he took from that. It was not to protect an actual claim for adverse possession, but to force Iftikhar to comply. And then in paragraph 91, he deals with cross-examination on that topic and gets to the point that at that time, Vacar, to the upshot of 91, was now saying to the court, before His Honour Judge Gerald, that in fact, back in 2011, he had thought he was an adverse possessor in his own right, but he was saying the opposite to his trustee. He was trying to convince the trustee that he didn't have an adverse possession claim. So it's another instance of the disingenuousness that understandably didn't impress the judge, but also informs the fact that he was then to be peddling the same line to Mr. Jarvis. He'd be telling the trustee, no, don't worry about it. This isn't my flat, it belongs to my dad. I don't have an adverse possession claim. That's what he's been saying to the trustee for a year. That's relevant to know when you then look at what he's saying to Mr. Jarvis in proceedings that also involve the trustee. Paragraph 92 deals with the hearing before Mr. Jarvis, and we have important factual findings here. We have a finding that Vacar had read the skeleton argument, and we have a finding that Vacar understood that if the stay were lifted, there'd be no adverse possession defence. And if it were not, and the claim was struck out, then there would be. The judge rejected Vacar's evidence that he didn't understand that point. That's factual findings. Paragraph 93 sets out the first, and described by the judge as the crucial exchange on the transcript. You can see that it begins with Vacar volunteering that it had been a mistake to make the adverse possession application. We shouldn't have listened to our solicitors and barristers. It's the same line he was giving to the trustee the previous year, and of course the previous year. We're feeling insecure. The reality you can't change facts, family property, and so forth. And as Judge Gerald goes on to find, what Vacar is doing here is he is introducing this, volunteering it, to try and convince the judge in the same way he tried to convince the trustee that he didn't really have an adverse possession claim to the property. And as you know from paragraph 130 of the Jarvis judgment, he succeeded in convincing Mr. Jarvis of that. You see the judge looking for clarification, directed exactly to this question. And you see that Vacar's response begins effusively with an "I want to be truthful and straightforward with you." And there's then some legal reasoning, which may or may not be correct, but the upshot of it is that he is still communicating to the judge, being truthful and straightforward with you, that I don't have an adverse possession claim. I'm not intending to pursue one. This is an example of the sort of thing that His Honour Judge Gerald is talking about, part of Vacar's modus operandi, where he is adept at giving a clear impression. Here the clear impression is I don't have an adverse possession claim. That's the whole thrust of this, even while what he says is somewhat evasive and opaque. Then, as you know, there are some other bits of transcript also that passed between Vacar and Mr. Jarvis. There was an exchange in relation to the position of Sarah, and there was a later clarificatory exchange where the judge expressly sought clarification of the point. Those are set out in Mr. Justice Bacon's judgment. They're not set up by His Honour Judge Gerald in terms, but he's clearly aware of them and is taking them into account. They've been dealt with in some detail before him. And he cites later on part of Mr. Jarvis's judgment that refers back expressly to those exchanges. It's not like he's unaware of them or is overlooking them. He's plainly factored them in. When one gets to paragraph 94, we're back into important factual findings. There's a finding here that Vacar understood the concern that if Iftikhar failed to lift the stays, he was prejudiced because of the adverse possession defence in new proceedings. And we have an important finding, 4 lines down, that the reason Vacar told the judge the adverse possession application to the land registry had been a mistake was to hinder Iftikhar's application to lift the stay. So these are factual findings about what Vacar was setting out to do, which has convinced the judge he didn't have an adverse possession defence for his own tactical reasons. The same way he'd been trying to convince the trustee of that for his own tactical reasons. And you see also that the judge considers a submission by Vacar's counsel that Vacar hadn't been asked specifically about the position if a primary claim to beneficial interest failed. So a submission had been made along the lines of, well, all Vakar says is, I'm not claiming adverse possession because I say I own it, so I can't. And Vakar's counsel had made the point to his Honour Judge Gerald, well, no one actually said, ask Vakar specifically, but hang on, if your primary claim fails, do you have an adverse possession claim as a secondary position? And the judge, as in my submission he was entitled to, rejected that submission. This is sentence beginning 7 lines down. He says there's no materiality, that he wasn't asked specifically about that. He well understood, and it was self-evident to Vakar, being the very reason for the exchange. Again, important. There's a finding that Vakar volunteered this information to the judge, specifically to close down the potentially damaging objection, i.e. to close down the point about prejudice by reason of an adverse possession defence, which was a point taken into Carr's favour on the application to lift the stay. So there's a finding that Vakar was volunteering it specifically to try to stymie the application to lift the stay. Alongside, of course, other motivations which have been dealt with in relation to what he was saying to the trustee, just generally trying to hide his claim at this point. There's also a judicial explanation from the judge here that this was of a piece, this is the final sentence of this paragraph, was of a piece with what I've described as Vakar's modus operandi, the way he'd be giving evidence before his Honour Judge Gerald. This is someone who was adept at hijacking cross-examination, deflecting the question, putting forward his own agenda, and demonstrating his intelligence, sophistication, and ability to manipulate and control scenarios to advance his own agenda and case. So that is again relevant. That's what he's doing with Mr. Jarvis. This is what Judge Gerald thinks he's doing with Mr. Jarvis. He is giving answers which succeed in giving Mr. Jarvis the very clear impression, which is the impression he wants to give, even if he does it in a way which is at times opaque, evasive, serpentine. Paragraph 95 has more important factual findings to similar effect. Again, there's a rejection of evidence that Vakar didn't understand. He finds he well understood what he was saying, why and what its effects might be. He rejects a submission or a suggestion that Vakar was asking the judge for advice. And again, we see the same approach from his Honour Judge Gerald, acknowledging that it might look like that on the transcript. When properly understood and seen in the context of the letters to the trustee, which of course were part of the context for his Honour Judge Gerald, also part of the context would have been before Mr. Jarvis, it was merely part of an exchange in which he knew and understood full well that the adverse possession claim was an alternative to his partnership claim. And the reason why there was the exchange was because he understood that a factor being taken into account in the decision to lift the stay was the issue of adverse possession as an alternative to the existing claim. And if the stay was lifted, that would be damaging, if not fatal, to his ability to claim adverse possession. Again, factual findings and important ones. 96 then quotes the most relevant passage of the Jarvis judgment. Paragraph 97 agreed with an earlier decision of Mr. Justice Fogg that it's clear that the underlying basis of the Jarvis judgment was that it would be appropriate to start proceedings afresh on the assumption that a defence of adverse possession wouldn't be advanced. Because the person opposing the lifting of the stay was effectively saying there was no prejudice if the stay remained. And then at 98 to 99, you get further conclusions. You get the conclusion that this reveals a masterpiece of dissembling and manipulation, which is sort of a piece with all that I've been picking out so far. Having said his half-truth and denial of adverse possession to the trustee, he repeated his denial of adverse possession to the deputy judge. So you get there the importance of looking at the two together. It's the same song he's singing throughout the period. And you get, picking up on my Lady Justice Asplin's question earlier, I say this is another instance of the same factual finding coming through again. He repeated his denial of adverse possession to the deputy judge. So there's a finding being made about Vakar's motivations, about what he was trying to achieve. There's also a finding being made about what he did achieve objectively. The objective effect of the judge's finding is that he repeated his denial of adverse possession to the deputy judge. and you get a finding that these exchanges were part of one gets the M99, one gets the finding is part of the campaign by Vacar strategy to keep the flat by hook or by crook. And I'm sorry, I should also have picked out the final part of paragraph 98, the penultimate sentence. It's another instance of the same factual finding as to what the effect of what was actually said to the judge. And then at paragraph 100, you get a conclusion. This is the merits-based assessment on abuse that the judge set himself at the beginning, that it would now be an abuse and the court shouldn't permit it. And I will be saying that's a broad merits-based assessment for the trial judge, which, although not discretionary, is one of those multifactorial assessments with which an appellate court should be slow to interfere. And I would also note you get again a clear statement, a reference to Vacar's disavowal before the deputy judge of an intention to bring the claim for adverse possession. I'd say again that's an indication that the judge is making a factual finding about what the objective effect of the statement was, as well as the factual findings he's making about what Vacar was seeking to achieve by the statement, and about what Vacar did achieve by the statement. So those are the factual findings. I've taken a little time on them because they're important.
Is
Yes.
his finding that the abusive process consisted only of what Vacar said to the court, or is he also rolling into that what he said to the trustee, which enabled him to escape the trustee assuming any right in the property by keeping it away from his creditors?
Well, the statements of the trustee certainly roll into his assessment of what was said to the court. I mean, it's very much part of his reasoning that you have to take both together. The abuse he identifies, yes, I mean the heart of this abuse is inconsistent positions before the court. He is undertaking a multifactorial assessment of all the facts, and so that I'd be wrong to say it doesn't feed in. So I think my submission is that the heart of the abuse is what happened before the court, and the position taken to the trustee, which was itself then part of the material before Jarvis, is a highly material part of what was said to the court. He also, I think, would have to take into account the whole thing as well as part of the fact. Now, I've gone through that in some detail. Those are findings of the trial judge. They're findings after hearing evidence. And as Mrs. Justice Bacon recorded, we'll come to this, it's paragraph 51 of her judgment, they're not challenged by Vacar on appeal, at least so far as concerns the statements about Vacar's understandings and intentions and motivations. None of that is challenged on appeal, as the judge records. There's a point taken as to what the objective effect of the statements was, which in my submission, although Mrs. Justice Bacon disagreed, is an appeal for a factual finding. But as for motivations and intentions and understandings of Vacar, no appeal. Now, before I turn up the judgment of Mr. Justice Bacon and go through that, what I want to do is develop, so you know what I'm saying, I want to develop first the points I make as to the ways in which Mr. Justice Bacon went wrong. In a nutshell, the basis on which she overturned his Honour Judge Gerald was that based on her own reading of passages in the transcript, she concluded that Vacar had not made an objectively clear statement that he would not pursue an adverse possession claim. That's her decision in a nutshell. And what I'm going to be saying is that in doing that, she went wrong in 4 broad ways. The first of those ways is a point of law that the underlying premise of her whole decision that for these purposes one requires an unequivocal objective representation, clear objective representation to have been made to the court. in the same way that one looks for a clear objective representation, for example, in a misrepresentation claim or a promissory estoppel situation, in my submission that was not correct. The law here takes a broader view. I will be going on to say that insofar as one is needed, Judge Gerald had found that there was one, and that shouldn't have been interfered with. But the first point I'm making is that there wasn't a need for one. The law takes a broader view here, because one's dealing with an abuse of process type jurisdiction. So, for example, if you have a situation where a litigant says something with a positive intention to give the court the impression that Proposition X is true, and in this case, we know that's what Bacar was doing, because those are the unchallenged findings on Judge Gerald. And if the court then forms the impression that Proposition X is true, which we know is what happened here, because it's completely clear on the face of paragraph 130 of Mr. Jarvis's judgment, as every judge who's looked at it since has accepted. If that happens, the litigant sets out to convey X and the judge receives X, there is no good reason why that should not be enough for the purposes of this doctrine. It doesn't matter if the litigant expressed himself in a way which someone else looking at it later can look back and say, well, actually, that was rather ambiguous. Actually, that wasn't that clear. If the litigant knew what he was seeking to say, and that's how the judge understood him, then why should it make any difference at all? There's no reason why it should. There's nothing in the authority to say it should make a difference. Especially in a case like this, where we know the litigant is one who, as Judge Gerald found, sets out to express himself in manipulative and less than totally straightforward ways, is adept at creating a clear impression while being less than clear-cut when one reads it back on the transcript.
So, Mr. Mumby, you say that what is necessary is an intention to deceive and the court having been deceived.
I say that that is sufficient.
Exactly, those are the elements. An intention to mislead, let's put it like that, and the court having been misled.
To be clear about what I'm saying, I say that the doctrine is a broad one, and what one looks for is a clear inconsistency of position.
Okay.
And when one asks what constitutes an inconsistency of position, the court will take a broad, practical, realistic look at how you determine what the party's position was first time. If there is a clear objective statement, in a case like that, that would be enough. In another case, where you have the two elements that your ladyship has just identified, that will be enough. In another situation, let me give another situation, that a litigant allows the court to form an impression as to the litigant's position and allows the court to proceed on that express basis and sits quietly and says nothing while the court proceeds on that express basis. In my submission, that will be enough.
Is an intention to deceive a necessary part of your argument? Take a case where he honestly believed that he wasn't going to make such a claim.
Yes, I've not been as clear as I should there in answer to my lady's question. Your Lordship is absolutely right. It doesn't need to be an intention to deceive, it's an intention to create the impression X, whatever X is. I mean, there's added, from my client's point of view, there's added icing on the submission here from the findings as to deceptiveness and manipulation and so forth. But what's central is that there's an intention to create the impression which is in fact created.
And so you go as far as to say that sitting still and quiet and allowing something to unroll is sufficient, but we don't have to think about that. But you do say that there has to be a subjective intention to create a particular impression in the circumstances that we're actually thinking about.
In the circumstances that we're in, I would also say, and I made the submission to the judge and it was rejected, that the failure to correct should be enough. So I do, I'm afraid, make the submission that my lady was anxious to clear away, but I'm afraid I do make that one. So those are three examples. Yes.
On the question of deception, I think you said you don't need to establish what's necessary for a case in fraudulent misrepresentation. But in a case of fraudulent misrepresentation, if A makes an ambiguous statement, deliberately intending it to be meant in manner X, and it is understood in manner X, is that not enough for a claim in fraud? If you can't answer, it's not essential to this case.
My lord, it may well be that it is. I'm cautious to give an answer snap off the hoof because that exact question in the fraudulent misrep context of what one does in the situation of an ambiguous statement is a hot one. But I think my lord may be right that if you actually know that it was intended subjectively in the relevant sense and it was picked up in that sense, that may well be enough. But I don't need that submission. In my submission, looking at
yours is intention to create a particular impression, and the impression was created and accepted.
Yes.
But you would go as far as to say failure to correct an impression which has been given.
Yes,
Okay.
I would say. I mean, all of these. When one asks what's needed to show that the parties there's a plain inconsistency, these are all examples. And these three examples all arise in this case. I say in our case, there is an objective statement when one construes it all together. That's how one should read the findings of Judge Gerald. He did find that objectively was what was conveyed, and he was right to do so, and Mr. Justice Bacon was wrong to go behind it. That's enough. But even if that's not right, I say you have a finding that there was a subjective intention to convey a particular impression, and that's the impression that was conveyed, and that's enough. And there's something faintly surreal about a court later looking and saying, well, I can see an ambiguity even if no one at the time could see it. And I also say, my lady, third, as your ladyship says, sitting back and allowing the impression to be created is enough. Or maybe in any given case, and it is in this case.
Depends on the facts.
It depends on the facts, but in this case, would in my submission be sufficient? One can see other examples as well, which perhaps don't arise in quite the same way in this case. If no one says anything at all about the relevant point, because no one's thinking about it, but on analysis it's inconsistent with what the litigant is claiming or the litigant is saying, that might be enough. That's the scenario that comes up in the authorities. We'll see some of those, which no one says anything at all about the point because it's not in anyone's mind yet. It's only later that you can look back and say, well, hang on, if that was your point, you should have raised it then, because we can now see that what you're saying is inconsistent. So all of this goes to show in my submission that the idea that one needs a clear objective representation, as one would said in a promissory estoppel situation, perhaps the parallel to deceit was an over hasty one, but in the promissory estoppel situation is not right. Now, as to the authorities, and I am going to go through some of these, I'm afraid, as rapidly as I can, but I'm not sure there's a way through it. It is a striking feature of this area of law that there are some strands of authority, several, which do not all entirely agree on the characterization of the relevant principle or principles. Some talk of approbate and reprobate, some talk of abuse of process, some more recently, or one more recently, borrows American terminology and describes it as an estoppel, a form of judicial estoppel. Nor do the authorities all necessarily express themselves in the same way as to the test. They do, in my submission, all involve taking a broad, pragmatic, merits-based view as to what an impermissible change of position consists of. And none of them give any support for the idea that there is a requirement for a clear, objective representation of the promissory estoppel sort. And I think the number of authorities has gone up a little bit at every stage of the appellate process, I'm afraid. As we are now, the parties' researchers have, I think, a run of half a dozen authorities. The first is Gandhi and Gandhi, which is tab 2 of volume 1 of the authorities bundle. This is the Court of Appeal in 1884. I'll try to recap the backstory as rapidly as I can because it is relevant and then go to the relevant bit of the reasoning. This was a dispute under a deed of separation between a husband and a wife, which had provided for the husband, among other things, to pay maintenance for the daughters of the marriage. After the making of that deed, there had then been an act act of adultery, and there had then been judicial separation proceedings, which had led to custody being given to the wife, custody of the daughters. And it had also led to a claim by the wife before the President of the Probate and Divorce Division for increased alimony under the court's own jurisdiction, more than the deed would have allowed her. And those alimony proceedings, the alimony claim, had gone on appeal to the Court of Appeal, and the wife had lost, because the court had proceeded on the footing that despite the change of custody, the husband was still liable to pay for the maintenance of the daughters. One then got to a subsequent round of proceedings, which was the round now before the court, in which the wife was having to sue the husband under the deed to enforce the obligation to pay maintenance for the daughters. And the husband now was taking the point that the giving of custody to the wife had in fact, on the terms of the deed, put an end to his liability to pay maintenance. So that was the nature of the switch, and the relevant bit begins on page 77. The various other points have been decided first. This is Lord Justice Cotton. You see at the bottom of the page, the beginning of the side-lighted part, the Lord Justice summarising effectively what I've just summarised to your lordships and your ladyship. Sorry, your lordship and your ladyships. That was the point now being taken. And you then get, on the next page, Lord Justice moves on to describing the previous proceedings and summarising what had happened there. At the foot of the page, he summarises that the Court of Appeal then, in deciding the appeal, went on two grounds about adultery, but the second one is they considered the question whether there was ground for increased maintenance. And in answer to the point raised by the counsel for Mrs. Gandy, they said that no greater burden had been thrown on her by the order that she should have the custody of the children, for that there was still standing the provision in the deed by which the husband is to provide for the expense of their maintenance and education. And then, rather strikingly, Lord Justice Cotton says, whether it was then contended by Mr. Gandy's counsel that that was the true construction and effect of the deed, I do not now recollect. But certainly the judgment in his favour was based on this, that if the deed stood, there was no ground from alteration of circumstances. He carries on. And then to explain that was part of the reasoning. Then in the next paragraph, he explains that Mr. Gandy is now putting forward a contrary position. And then in the bottom of that page, onto the next page, what should we do? And he explains the inconsistency as an unsatisfactory one. It would be wrong, in my opinion, to allow him to take advantage of a decision given on one construction, whether accepted by him or argued by him, and to give another decision in his favour on the ground that that was not the true construction, accepted or argued. And then what they ultimately do is, how the story ended isn't actually clear from the report, because they adjourned it to allow the previous proceedings to be revived. And what happened after that, at least I can't assist this court with. And then over the page, one sees Lord Justice Lindley is in agreement, and so too is Lord Justice Bowen. And again, in Lord Justice Bowen's judgment, I just note about halfway down the first chunk of it on page 81, in order to arrive at the second ground, which is vital, I think, to the decision, it was taken for granted with the acquiescence of Mr. Gandy by his counsel. So again, his acquiescence is enough. Mr. Gandy still acknowledged continued liability. And then in the next page, you see some more language from Lord Justice Bowen explaining why he thinks this is an unsatisfactory position. Having got the benefit of the decision on one ground, he turns around and declines to contribute to their maintenance of education. And then in the middle of the page, there's a sentence, whether it is raised judicata or not, it seems to me there would be monstrous injustice if the husband, having suggested one construction of the deed in the old suit, actually when he says suggested, what he means is acquiesced. and succeeded on that footing were allowed to turn around and win the new suit on diametrically opposite construction and be playing fast and loose with justice, if the court allowed that. So one sees there's definitely no need for a clear statement. In fact, sitting back is enough in that case. Doctrinally, what the nature of the doctrine is that they're citing isn't yet clear. They don't give it a name. The language is simply that of monstrous injustice and playing fast and loose with the court. Jumping forward then, I'm so sorry, it's actually in the same. Jumping forward then to tab 10 is Circus Brown Wilkinson, the Vice Chancellor, was an Express newspaper news to make a familiar decision to the court, and one that's cited not infrequently. This was litigation between the publisher of the Daily Express and News UK, which was the publisher of both Today and the Daily Star.
So sorry, I missed the bundle reference. Tab.
So sorry, my lord, tab 10. So this was litigation from the publisher of Daily Express and News UK, which published both Today and the Star, and it was a claim for breach of copyright. And what Daily Express was saying was that Today had copied a Daily Express exclusive interview article without permission, and that was a breach of copyright. And Daily Express had obtained summary judgment on that claim. In the meantime, News UK had issued a counterclaim saying that the Daily Express had done the exact same thing to a Daily Star article. So by the time this got before the court, Daily Express had got summary judgment on its claim, and News UK was now seeking summary judgment on the counterclaim, which was effectively the mirror of the claim that had been successful. The Daily Express put forward various defences which were hopeless that don't need to concern us, but there was one defence which, other things being equal, the Vice-Chancellor held would have merited going to trial, namely a defence that there was an implied licence to copy based on an established custom of newspapers copying each other's stories in that way. And I won't take you through it in detail, but that's all set out on page 1328, is where that defence in the bottom half of the page is sketched out. And although that was an arguable defence which otherwise would have gone to trial, the Vice-Chancellor held that Daily Express couldn't advance it, because if it were right, it would have been inconsistent with the claim on which it had obtained summary judgment. And that takes one to page 1329. Beginning, well, the sidelining is, therefore, apart from the mirror image aspect of the case, I would have given the plaintiff leave to defend, so as to enable them to lead evidence on the implied licence defence. However, I come back to the first point, which greatly impresses me, and then he sets out the fact that summary judgment had already been obtained. And then the paragraph just below E, just above F, the fact is that if the defences now being put forward by the defendants in relation to the Daily Star article are good defences to the Ogilvy case, they were and are equally good defences to the claim by the Daily Express against Today. I think that what Mr. Montgomery describes as what is sauce for the goose is sauce for the gander has a rather narrow legal manifestation. He says there, principle of law of general application is not possible to approbate and reprobate. You can't blow hot and cold. You can't take inconsistent attitudes. To apply that general doctrine to the present case is, I accept, a novel extension. Not quite, in fact, if he'd had Gandhi cited to him, but he hadn't, seemingly. But in my judgment, the principle is one of general application, and if, as I think Justice said, requires no reason it shouldn't be applied, which he goes on to do. And then it's also worth looking over the page at the last part, where he says, it's true that on the Order 14 application in relation to the Borders article, this was the original summary judgment application, Today didn't raise the defence of implied consent. So it wasn't even being mentioned on the earlier occasion. No one said anything about it. It wasn't mentioned as a possible defence. I think one can take it from that it can't have been the case that the Daily Express said nothing about it at all, let alone an unequivocal representation about whether it would run such a defence in future. He says, but the fact remains the cases advanced by Daily Express on the claim and the case advanced by Daily Express on the counterclaim are wholly inconsistent. So, in my submission, again, one sees a broad and pragmatic look being taken to what amounts to inconsistency. Indeed, there you can see you don't need to have said anything at all first time round. No one needs to have been talking about it if the inconsistency is plain. The language there is some doctrinal language, and it's approbate and reprobate. And as I say, I'm sure that's a case which the court will have seen cited for those words, approbate and reprobate. It's the case one most often sees, is to my experience at that point where those words appear in someone's submissions. The next case is a case called Bradford and Bingley and Seddon, which is behind tab 14. And the point didn't ultimately run here, so I might be able to take it fairly briefly. This was a situation where Mr. Seddon was a mortgage borrower who previously sued and obtained judgment by admission against the accountant who advised him on the mortgage loan, Mr. Hancock. In the present proceedings, the bank had now sued Seddon on the mortgage, and he was now seeking to bring a third-party claim against Hancock, but also Hancock's two partners. And there were various Henderson and Henderson type points being run, but there was also a point run about inconsistency of position, and it was said that there was some language in the earlier pleading about the personal nature of Mr. Hancock's liability that made the two positions inconsistent. And what ultimately happened at pages 1497 to 1498 is that the court didn't think they were any more than arguably inconsistent. And in any event, as I would say, any inconsistency arose just from what happenstance the way the previous claimant had been put. There was no essential inconsistency between the two things that Mr. Seddon was seeking to do. There's no reference back either to Gandhi or to Daily Express. And what the court talks about here is in terms of abuse of process. And accordingly, the language which is used is abuse type language. And it's talk of the whole circumstances of the case.
Are we looking at specifically for that?
I was getting that about
498 at B, perhaps.
And D.
yes. It's I'm getting at D. I'm getting at D the point that what they're talking about, the way in which they're framing the issue, is as a point of abuse. And then one gets, as one reads through the rest of that paragraph, he's saying, well, not every inconsistency will be enough, because some may be consequential or inadvertent. And he's saying that you need other circumstances, you need to look at the other circumstances. It depends upon the circumstances of D, as my lady says, often whether some additional element is present. And he then gives various examples of the sort of situation that might make it abusive. So ultimately not a case that goes very far, but it's interesting to see this sort of topic being treated as one of abuse, and accordingly, depending on the circumstances. And again, there's no warrant in that authority, there's no support in that authority in my submission for the idea that there is a strict rule that in every case what you need to have is an objectively clear representation. I'm grateful to my lady for taking me to the relevant part when I failed to mark it on that copy. The next case I was going to take the court to in this run is second bundle of authorities, tab 39. This is a decision of Mr. Justice Mann in a case of claimants in NGN. This was a costs argument, and it was about whether, as the defendants contended, CFA uplift provisions, which could in principle be sought under the then rules in this sort of case, whether the seeking of them was incompatible with Article 10 of the European Convention in the context of privacy litigation. So that was the point that the defendants were seeking to run to resist these CFA uplifts. It's incompatible with Article 10. And what is important for our purposes is in the course of the substantive litigation, a point had been raised by the claimants that they should have an uplift on damages under the so-called Simmons and Castle uplift, which, as the court may recall, was the uplift introduced to compensate claimants for the abolition of the ability to recover CFA uplifts. And the defendants had successfully resisted a Simmons and Castle uplift on the footing that the present cases were publication cases. They were at that time a carve-out to the abolition of recoverability of CFA uplifts. And if you start on paragraph 26, I'm afraid I'm still on an unpaginated bundle page number, because it's about 5 pages in my copy. Under the heading The Estoppel Point, paragraph 26. Points introduced there. Those paragraphs 26, 27 and 28, it's explained, and the judge explains what the point was which had been taken in the substantive proceedings, which was about whether the Simmons and Castle uplift applied, given that this was not a type of proceeding which had been, for which CFA uplifts had been taken away by the new rules. And he ends at 30 with what the submission had been that the defendants had made below, wrong in principle to make the Simmons and Castle uplift, because under proper consideration Simmons and Castle didn't apply in a privacy case. 31, he says, plain the defendants had taken the point that the claimants had the benefit of CFAs with the opportunity to claim recovery of additional liabilities under their costs orders, and that fact prevented them from having the additional 10% in damages. The existence of CFAs and the right of recovery in relation to them was actually being relied on by the defendant. Although one may note, nothing had been said at first in the substantive proceedings about the specific human rights point that was being taken now. That wasn't a point that had been raised. 32, he says, that was the basis of my judgment on the point. Points out that in any given case, the defendant could have looked at an individual CFA and made specific points about it. However, the availability in principle of CFAs and the right to recover in respect of cases of this class, privacy cases, was not merely assumed but propounded and was part of the basis of my reasoning. And then 33, he cites, he applies the approbate and reprobate principle, citing express newspapers. 34, he continues that. He says, I agree that words can be made to apply in the present case. The work is obvious, it's classic approbate and reprobate. An inconsistency which should not be allowed. And he says an alternative way of looking at it is as an abuse of process. Whichever label one chooses, the present stance one they shouldn't be allowed to adopt. So one sees the language of approbate and reprobate and abuse. I also do note the point that, again, as in Daily Express, what was being done now was inconsistent with what had been done before, but it wasn't as if the point that was relevant now had been mentioned at all before. The point about the human rights defence had simply not been mentioned on the prior occasion. So again, one's looking at inconsistency in reality rather than mechanistically looking at is there a clear objective statement. The next one, which I will also aim to take, perhaps inspired to take relatively swiftly, is Twin Sectra and Lloyd's Bank, which is overturn at first instance. So it is what it is, but in circumstances where there isn't a totally clear
Tab number?
line to these, it's tab 41. These are proceedings between a borrower and a bank, a borrower company and a bank, as to the validity of certain charges. The bank was seeking summary judgment to the effect that the charges were valid, and the borrower company was saying they weren't because they'd been executed without authority. Our point arose because in previous proceedings, the borrower company, which was now saying the charges were invalid, had sued one of its directors, a Mr. Ackerman, for breach of fiduciary duty in granting the charges. And so the bank now took the point that in obtaining judgment in the Ackerman proceedings, the company's case on loss, as against Mr. Ackerman, had been premised on the charges being valid. And it said that the borrower company, having taken that stance, Mr. Ackerman couldn't now take a different stance when sued by the bank. Now, the judge in fact decided the case on the basis that in the earlier proceedings there'd been an election between inconsistent remedies, which is a different doctrine that we're not concerned with. But he did go on to address the point we are concerned with in case the matter went further, and that is on the internal numbering of this report is on page 68, on the penultimate page of the whole thing. Roman numbers 11 and 12. So it starts by saying,
Well, do you want us to read those? I don't think it's helpful for you to read it all out.
my lady, I'm very grateful. I
Find it. Is there, I haven't got page number. 68 of the internal.
That's right.
68 of the
And
internal
947
numbering.
of the bundle.
And you want us to read paragraphs 11 and 12, do you?
My lady, I'm grateful.
Thank you.
So again, it's put in terms of approbate and reprobate, and it's put in terms of abuse of process. And there is no suggestion that one is looking for clear objective statements. Against a situation where one could see that what the bank was, what the borrower was doing now was inconsistent with what it had done before, but it wasn't a matter of combing through its previous statements to say, well, there's a clear statement. And indeed, very little had been said, it seems, in the previous proceedings about the question of validity of the charges. It was simply assumed. So the next case I was going to look at is LA Micro, which is the case cited by Mrs. Justice Bacon. That's at tab 49. The facts in LA Micro were a little involved, and ultimately maybe the principles rather than the facts which most matter, but in short, there were two companies, an English company, a California company with similar names, which were parties to a joint venture. And there were a series of disputes as to who the true owners were of the English company. It was owned as to 49% by Mr. Bell, and the ownership of the remaining 51% had been the subject of various disputes. In earlier proceedings, one of the two owners of the California company, a Mr. Frankel, had sued for a declaration that he owned 25.5% of the English company. And the English company, Mr. Bell, had disputed that, saying that it was the California company itself which owned the 51%. The judge had accepted that. Now, in these proceedings, the English company and Mr. Bell were seeking a declaration that it was the other owner of the California company, Mr. Liampert, who was the owner of the 51%. So, if the facts were to matter, one would need to look more closely at quite what was said and how it played out. But that's the gist of what it was about, to orient your lordship and your ladyships. If you go to page 334, sorry, that must be a wrong reference.
No.
44.
If you go to, I'm so sorry, if you go to paragraph 18 on page 344, I'm very grateful to make.
Sorry, paragraph 80, did you say?
Paragraph 18 is the beginning of the
18,
relevant.
sorry.
18 on page 344
Thank you.
is the beginning of the relevant
Yep.
passage. What was striking is that of the cases we've looked at, I believe the only one that was before this court was Gandhi and Gandhi. None of the intervening cases had been cited. And the doctrine is therefore framed by this court in terms of estoppel, which is not the framing that we've seen in any of the other cases we've looked at. It may be that not much turns on the label, unless the label of estoppel tempts one to begin introducing features of promissory estoppels that have no home here. But if it is a temptation to start introducing those features, then it does matter. In my submission, it shouldn't matter because there shouldn't be any assumption that whatever label one gives this estoppel or otherwise, it would have those features. So paragraph 19, they introduce this concept, cite a case, Cocoon, which I think we've all spared the court. Glad to know that at least one case has been cited. They then cite Gandhi and Gandhi at 20. 22, not every change of position which creates this form of estoppel. And then the formulation in Cocoon is dissected as to, like Radcliffe's words are dissected. It said that it's important, well, it said that it's required that a party's stance was the means by which he procured the order, and the circumstances must be such the court has no option but to hold him to his former stance. That is a prescriptive formulation which is not ultimately adopted in the way in which Sir Christopher Floyd in this case approaches it and says it should be approached. And it's also, if one reads it in that prescriptive way, not consistent with what the run of the authorities so far has shown. And he then cites what's said in Gandhi and Gandhi on the ground that and on the footing that, and he says these phrases suggest it must be apparent from the earlier judgment that the stance taken by the party was a reason for the judgment which he obtained, and that it would in all the circumstances be unjust to allow the party to resolve the stance taken earlier. I wouldn't cavil with that. And as Mr. Justice Bacon held correctly, he says there is a reason, not the but-for cause. And then the court looks at the similar doctrine recognised in the United States and goes in some detail through the US case of New Maine and Hampshire, which we also have in the bundle, might look at briefly, which was a boundary dispute between those two states. In circumstances where there'd been an earlier dispute in the 1970s about the marine boundary, which was settled by reference to the meaning of the phrase, the middle of the river, in a particular river. And then there were later proceedings dealing with the inland river boundary. So the earlier proceedings dealt with the marine boundary, the bit that goes out to sea based on where's the middle of the river. The later proceedings dealt with the inland, where's the boundary as you go up the river. And it was held that New Hampshire was bound by the position which it had assumed or accepted in the earlier proceedings. And in 24, so there's the quote there from Justice Ginsburg, where a party assumes a certain position, succeeds in maintaining that position, he may not thereafter, simply if his interests have changed, assume a contrary position. I say position there can be taken broadly. And then the purpose of the rule is explained at 24, protect the integrity of the judicial process by prohibiting parties from deliberately changing positions according to the exigencies of the moment, preventing parties from playing fast and loose with the court. Pausing there, that's not the sort of policy which would suggest that one needs an absolute rule of a clear objective statement. It would suggest a wider and more, if I can put it in this way, reality-based approach to what is a party's position. Ginsburg observed that the doctrine, which at least in the US is an equitable doctrine, though I'm not sure we'd say it's an equitable doctrine here, we'd regard it as part of the court's, the general doctrines that govern the court's process, was not reducible to any general formulation of principle. That's important. it's a justice of the case, it's not of their restrict rules. Ginsburg identified a number of factors which typically inform a court's decision as to whether to apply the doctrine in any individual case. So again, these are not rules, these are typical things that one would look for generally in an overall decision. First, a party's position must be clearly inconsistent with its earlier position. Now that is the form of words which my learned friend makes a lot of and which seems to have lodged with Mrs. Justice Bacon. And in my submission, it is an over-reading of this judgment, and in any event, inconsistent with the previous authorities, to spell out from the need for a clear inconsistency, which I accept, the need in a previous case to have had a unequivocal objective statement. A clear inconsistency as a matter of reality does not require that, and there's nothing to suggest that it does. And then there's also importance given to whether the party succeeded in persuading the court to accept the position, and whether the inconsistent position would enable the party doing it to derive an unfair advantage or impose an unfair detriment. And they then say the author Spencer Bauer says there's no reason to assume the law of England is different. And he concludes, therefore, in 26, it's clear, therefore, that this form of estoppel by conduct, as he describes it, is one which is approached by means of a broad, merits-based assessment and is not constrained by strict rules, as, for example, issue estoppel. In my submission, that, even on the face of this case, is inconsistent with the judgment of Mrs. Justice Bacon, because she is importing a strict rule and one that just this authority, none of the authorities support. The matters to consider include, but are not limited to, those enumerated by Justice Ginsburg in the New Hampshire case, and then material to ask the question whether it's apparent the earlier decision was obtained on the footing of or because of the stance taken by the party, which in my submission, and on this point Mr. Justice Bacon agreed, as did His Honour Judge Gerald, and as in my submission would anyone reading paragraph 130 of Mr. Jarvis's judgment, it's clear the decision was obtained on the footing of the stance taken by Vacar. So that has been, I'm conscious, a lengthy review of the authorities, and as so often when one is reviewing authorities and seeking to prove a negative, one has to travel a long road to go on maybe a short distance. It's the only one of the points I take on this ground of appeal which requires one to do that. The court will be glad to hear. Where one arrives at the end of that is that there is no rule that you need an objectively clear representation. That was a submission made by my learned friend seeking to import requirements of promissory estoppels. There is no basis in the authorities to do that, and indeed to do so is contrary to the authorities. It is also contrary to the underlying policy, purpose of the principle. And in my submission, that emerges very clearly from the suite of examples with which I began these submissions. In my submission, those are all scenarios. There's a subjective intent to communicate something, and that is the meaning picked up by the judge, or when a party sits by and lets the court proceed on one footing, or the point's simply not discussed but can be seen later to be inconsistent, which is the scenario in Daily Express and in other cases. Those are all situations where the policy is obviously engaged and there is an obvious need to apply this principle, but there has been no clear objective statement. It is right to say that the judge appears to have been under the impression that it was common ground, ultimately. There had to be a clear statement of position viewed objectively. That's what she says in paragraph 44 of her judgment. So far as we are concerned, it was not common ground. And we have, as you will imagine, looked anxiously trying to find a record of us making such a submission or making such a concession. We haven't found one. And in our submission, we were clear that we were opposing the introduction of rules of promissory estoppel, and that we were upholding the relevance of subjective intent. And that emerges in my submission, what we said, and I'll go below what we said to the judge below. In the event, I don't know whether my learned friend will take the point in the event it will be said that we succeeded in making that concession inadvertently, as it were, I would formally ask to be permitted to resile from it.
So
in
I've just
circumstances.
turned up paragraph 44. And what the judge said, that you did not, however, ultimately disagree that to establish an abusive process on this ground, it must be shown that there had been a clear statement of position viewed objectively, and that the court did rely on that position, and you're now seeking to resile from that submission.
Well, my lady, my position is I don't consider the judge was correct. I think it was
Did
my
you get a
position.
draft judgment?
We would have received a draft judgment, yes. It didn't at that time appear to us to be a point which it was appropriate to seek to reopen the judgment on. I think it's also right at that time we didn't have a transcript of the hearing as yet. I think that's correct. So it wasn't possible to provide the judge with the transcript to say, well, there's that's not how
Perhaps
it
your
was.
junior could give you the reference to your written submissions about this part.
Yes.
Don't want to take you off track
No,
where you go to it now, but
absolutely.
it would help me certainly. Just
If you look in the supplementary bundle at tab 23, the supplementary bundle.
It goes a bit further, doesn't it? Because at paragraph 45, the judge is saying, Mr. Mumby said that in order to establish how objectively a representation of a position taken in litigation should be and was understood by the court, etc., etc. So she's weaving in.
I certainly was also saying what was said at 45.
Okay.
But I wasn't saying that, at least as I understood what I was saying, I wasn't saying that instead, I was saying it as well.
Okay.
I think the best bit from our written submissions below would be paragraphs 25 to 29 on page 207. Sorry, 207 is the start. Paragraph 25. Yes, begins on page 207.
Okay, so you've got a subheading.
Yes.
The submission that Valgar did not make a clear and unequivocal statement intended to be acted upon, which might
Yes.
seem to suggest that your approach was that there needed to be one.
Well, my lady, if I could take the court to the paragraphs.
Yes, of course.
25 gives one the assertion that was being advanced by the appellant that no abuse process could arise unless the statements made by Vacar were sufficient to generate a promissory estoppel. That was the point. That submission that the statements had to be sufficient to generate a promissory estoppel, that was the submission that you needed a clear and unequivocal statement. So that's what we were responding to. And what we were saying in 26 is, this is the first of several attempts by the appellants to assert the existence of hard and fast rules by which the presence or absence of an abuse can be tested. And we say that's not right, and we cited Johnson and Gore-Wood and the passage from LA Micro. So what we were saying was, in response to the case being advanced, which was that there was a hard and fast rule that you needed to satisfy the requirement of a promissory estoppel, namely a clear and unequivocal statement, we were saying that's not right, no hard and fast rules. And then in 27, we were developing that point further and saying that while there were parallels with promissory estoppel drawn by the appellant, by Vacar, neither of those two judgments that were referred to, either the early judgment Miss Justice Falk in this case or Miss Justice Mann in the A representative claimant's case, actually provides any support for importing the requirements of promissory estoppel. And then 28, the true question, as in LA Micro, whether or not Vacar's position before Mr. Jarvis was clearly inconsistent with the position taken in these proceedings. And we say the answer is clearly yes. And that is the same submission that I make to this court today. And my understanding of the position that we were advancing was that it was clear that while we said there had been an objective statement, that was the finding of the judge below, and it was a right one. We were also saying that it was not right that you should bring in the rule from promissory estoppel that you needed one. And I was not conscious of having abandoned that position. So I do say that in those paragraphs, the judge has slipped in recording an absence of disagreement when there was one. Even Homer may nod, and even the judge, the experience and ability of Mrs. Justice Bacon may nod. By submission, that's what's happened there.
Thank you.
To the extent that I need it, if I need it, though I say I don't, I would seek permission formally to resolve for it, if there was something I need to resolve from. As it was a submission on a point of law taken before a first appeal court, now before a second appeal court, it's not as if it would have affected the evidence or anything other than the way in which the legal argument is developed.
Understood.
So that was the first of my 4 submissions, and I should say it's by very long way the long one, because it's the one that involves all the law. The rest can be made more shortly, and then I'll take a little time to look at the judgment, and then I'll move to the adverse possession points. So the second way the judge went wrong in my submission is that she usurped the functions of the trial judge in 2 respects. First, insofar as one does need an objective statement, contrary to everything I've just been submitting for the last, probably feels like quite a long time, insofar as one does need one, in my submission, Judge Gerald had found that there was one. Highlighted passages in paragraphs 8, 98, 100 of the judgment, where in my submission that is what he is finding. That was for him, and Mrs. Justice Bacon, with respect, shouldn't have gone behind it. You have in the bundle, though I'm sure it will be very familiar to you, the statement of principles in Volpe and Volpe, which is a recent decision of this court, gathering the well-known principles as to the deference to be given to the trial judge on findings of fact. That's tab 52, and in particular the need to be cautious about analysing the way in which findings are expressed too close to analysis.
We can more or less all recite paragraph 2 of Lewis and LJ's judgment by now.
I'm glad that my
As
assumption
no doubt all of you can also.
was a correct one. And we've also set out our skeleton argument another passage which was cited by the Supreme Court in a case called McCraddy, approving a statement of the US Supreme Court as to why one defers to the trial judge, which isn't just about the trial judge being in a better position, the evidence they have available to them, it's also about that being the trial judge's job, not the job of the appellate court. So in my submission, the view that was taken, and as we'll see it was expressly taken by Mrs. Justice Bacon, that she was as well placed as the judge below to decide what had happened before Mr. Jarvis, because she had the transcript, was not a legitimate step for an appellate court to take.
Is that your second point? Or
This
are we
is-
still on the first point?
We're on. I'm so sorry. I have 2 numbered lists running. I have my.
Sorry, we've got I'm on number 2, usurped the trial judge,
Yes,
which I then called A, so I didn't get confused about ones and
I'm
twos.
very grateful. We're still in 2A.
And we're still in 2A, thank
We're
you.
in 2A. We're in the judge usurping the trial judge on the facts. And so she shouldn't have been doing it in principle. And in my submission, she also, in this case, wasn't in a position to do it. As we'll see, it was evidently a poor transcript of the hearing before Mr. Jarvis. And in any event, as one knows, the transcript doesn't tell the whole story, because what the parties say is read in the context of all of the other submissions that have been made by the court, what everyone in court knows about what everyone's position is, all of the written evidence and the written submissions, and indeed, particularly with a witness or with a litigant who expresses himself in the way in which Sergeant Judge Gerald has described, the actual lived reality of the conversation. So in my submission, when one considers both the importance of all the things that surround the transcript passage and the poor quality of the transcript passages, this was, both in principle and very importantly in practice, a question for the trial judge. His Honour Judge Gerald had advantages that Mrs. Justice Bacon did not. He was absolutely immersed in this case after trial. He had all of this, all the factual matters before him. He'd heard the witnesses, and he was seeing the transcript passages in all their surrounding context, and had heard cross-examination on them. So it's not the same, it's not right to say, even if we're right in principle, it's not right to say, well, I've seen the transcripts, I'm in the same position. Adopting my lady's better subnumbering, 5.2b here, as to usurping the function of trial judge, is that, as well as usurping him on the factual findings, the ultimate question involves a merits-based assessment, which is not of discretion, but it's one of those broad assessments on which an appellate court should defer to first instance court. That's my second point. My third point builds on the last two. Even if it were right that an objectively clear statement was needed, and even if it were right that the judge was within her rights to go behind His Honour Judge Gerald's factual findings, her conclusion is in fact, in my submission, not a realistic or a supportable one, because it involves finding that Mr. Jarvis was very profoundly mistaken as to what was happening in the hearing before him, on what was a central point in his judgment, and one he had expressly gone back to check carefully. And it also involves thinking that not just he, but also others in the room had misunderstood what was happening, including the Trustees' Council before Mr. Jarvis, who clearly also thought that Vacar had disclaimed an adverse possession defence. And in my submission, that's just not plausible, and certainly not a conclusion that one could reach based on the transcript alone. And the fourth point, which will have to be made in turning the pages of the judgment briefly, is that even leaving all those points to one side, the judge's reasons for reaching the conclusion that she did don't do the job. And for that, and the last thing I was going to do on this topic before I move to adverse possession, is turn the pages of the relevant part of Mr. Justice Bacon's judgment, having told you what the points are going to be. So that, as all knows, is tab 14 of core bundle. The relevant passage begins at paragraph 38 on page 182. Sets the point up. 39 is my submission. 40 to 43 begins setting out the law, summarises some of the authorities we've just looked at. There were others as well before the judge and still more before you. Which do help to illustrate the lack of need for a clear objective statement. And the doubtfulness as to whether the estoppel label is necessarily the right one, or in any event, whether one can attach too much significance to the estoppel label for what the content of the rule is. Paragraph 44 introduces the idea of a clear and unequivocal representation on an objective basis by analogy with promissory estoppel. And 45 is on the same topic that we've just been discussing. And in my submission, which I've made at length, that is wrong in both of those paragraphs. So wrong on the law, as which I've made. 46 is doubtless correct, making the point that if there was an objective statement, but it was made by accident, that might be material. But it is not an issue on our facts, not least because we know on the basis of factual findings exactly what Vacar's intention was. 47 to 49 record and endorse various findings of the trial judge. Of course, to that extent, I endorse it. It does omit, I would say, the findings which I say are to be seen in the judgment, that there was an objective statement. that Vacar disavowed his adverse possession claim. I submitted when I went through Sergeant Judge General's judgment that in my submission he was making that finding alongside the others he made. At 50 to 51, Mr. Justice Bacon deals with the points about the scope of the appellate court's task. She dismisses the point that abuse of process is an area where one should defer to the first instance judge. In my submission, she was wrong to do so. It's not right to say, well, this one's a bit less balancy than others, and therefore I can just remake it. She then goes on to deal with factual findings, where she does say that the court should be socially clear of factual findings, which is obviously right. And she rightly records Mr. Jordan not taking issue with the judge's findings as to credibility and character of Vacar, or related findings as to Vacar's understanding of what was said. It's important. Mr. Jordan's submissions on those points were confined to a challenge to the relevance of those findings to the assessment of abuse of process. And then 52 to 53, she does go wrong, in my submission badly wrong, because she takes the line there expressly that the question of what was said, the objective characterization of what was said, is not a matter of preliminary fact. Sorry, primary fact, but matters which the appellate court can deal with as well as the trial judge, because it has the transcript. And in my submission, that was my point 2A of my numbered list. That's wrong. The judge is express about what she's doing there, and it's not something she should have done with respect to her. One can well understand the temptation to which even the best judges, perhaps especially the best judges, may be subjected when they have a transcript to want to get back into it themselves. But when sitting, as on this occasion, Mrs. Justice Bacon was an appellate court, is a temptation which in my submission she should have resisted. One then gets to 54 to 60. That deals with Mr. Jordan's alternative point that it didn't matter in any event whatever Vacar said, because Mr. Jarvis was bound to strike the claim out anyway. That's the point which Mrs. Justice Bacon rejected. She was right to do so, for the reasons that she gives here, 54 to 60 and for others. That is a point which is sought to be revived by way of Respondent's notice. And what I propose to do, subject to the court, is to pick that point up in reply once the point has been opened, insofar as it is opened, as with the other Respondent's notice points. One gets back at paragraph 61 to her findings on the point we're now concerned with, which is the judge's characterization of, say, findings as to what Vacar had said. 61, she cites the relevant, the first transcript passage, which is the one that had been in Sergeant Judge Gerald's judgment. And in 62, she construes it, and she construes it in a different way from which the judge construed it. She says, Vacar was saying he couldn't make an adverse possession claim in relation to properties he partly owned. He was not saying that such a claim would not be brought, even if the courts were to find the property was in fact owned by Iftikhar. Now that is the very submission that had been made to His Honour Judge Gerald and rejected by His Honour Judge Gerald, paragraph 93 of his judgment. As part of his findings, both that was exactly what Vacar was seeking to convey, same as what he was conveying to the trustee and so forth, and also that it was what Vacar actually conveyed. So my submission 62 goes badly wrong for that reason. It's reopening the judge on the facts and going wrong in doing so, because the judge's reasoning findings were cogent ones. It's also plainly in my submission contrary to the way that Mr. Jarvis understood it in paragraph 130 of his judgment, he having been the judge who was in the room. In my submission, it is a somewhat odd result and an incorrect result, where all the people in the room understand it one way, And a judge in different proceedings years later says, well, actually, it meant something different.
Which paragraph did His Honour Judge Gerald make the inconsistent finding? Not 93.
It was, in my note, it's 93.
That's where he summarises the board quote.
I'm so sorry. In that case, it's the one where there's a submission made by Mr. Pettican, which he expressly rejects, which is
That's the
this
next
very
one,
submission.
94.
So I'm very grateful to you. And of course, in my submission as well, this paragraph focuses 64 of Mr. Justice Bacon, I'm so sorry, 62 of Mr. Justice Bacon's judgment, focuses on the wrong question, because the authorities don't tell you need a clear objective statement. Paragraphs 63 to 64 then bring in an exchange a little later concerning the position of Vacar's wife, Sarah. The judge says that this is revealing in that it shows Vacar seemingly being candid on this occasion. There are a number of problems with that. First, what the judge is doing here in reality is picking a bit of the evidence out of the entirety of the evidence that would have been before His Honour Judge Gerald, and saying that bit of the evidence I've cherry-picked lets me go behind his factual submissions.
So remaining with Lord Justice Lewison, island hopping
Lady.
is your submission on this.
Yes. So it's an illegitimate thing for her to be doing at the start. One would hazard the guess that if one suggested to His Honour Judge Gerald that this was Vacar being candid, Judge Gerald would have said, no, it's Vacar engaging in the sort of manipulative answers that are characteristic of all of his answers. Second, it goes wrong because, again, it involves Mr. Justice Bacon going behind what Mr. Jarvis had said, taking a view that she can do better by looking at one bit of the transcript, understand better than the judge in the room. And third, it involves her saying that counsel for the trustee in bankruptcy had got it wrong as to what was being said. And it's clear, indeed, from the transcript that the trustee in bankruptcy understood understood Vacar in the same way as Mr. Jarvis, because there's a passage where Mr. Jarvis says to the trustee in bankruptcy's counsel, it'll be very hard for you, won't it, given what Vacar's now said. And that is effectively accepted. It's in the supplemental bundle at page 94, tab 10. It's an interesting exchange. And fourth, finally, this whole point about the exchange about Sarah is a bit of a red herring in any event, because we're not concerned here with whatever rights Sarah might have. We're concerned with Vacar's own claim and what he said about that. Paragraphs 65 through to 68 concern then an incident towards the end of the hearing before Mr. Jarvis, during Miss Tipple's closing, when the deputy judge went back to Vacar to confirm his understanding of the previous exchanges. And this is what's seemingly referred to in paragraph 130 of the Jarvis judgment, where he says it was confirmed to me when I checked. And what one sees here, Mr. Justice Bacon sets out the transcript, and one can see it's not very good transcript. The key parts are missing under inaudibles. What is clear, as Mrs. Justice Bacon rightly says at 67, is that Mr. Jarvis understood it to be confirmation that adverse possession wasn't being pursued by Vacar or by Sarah and wouldn't be pursued in the proceedings. So we know how the judge understood it. He was actually there listening to it. Mrs. Justice Bacon is also right, insofar as it goes, to say that the inaudible passages present a difficulty in seeing what happened. What she then does in paragraph 68 in my submission wrongly is to go on to try to do that very exercise. In one instance, she tries to fill in one of the blanks and says, well, the word under the inaudible must be rights or something like that. My submission doesn't know that it's one word, it could be many words. And in any event, once one's engaging in trying to work out what's under the inaudible bit of the transcript, that should be a good indication to the court that it has most definitely slipped back into primary factual findings that should be for the judge. In other instances, she accepts that there are blanks, but tries to construe the remaining parts without the blanks. And again, one's back in what should be work for the trial judge, which had been done for the trial judge, and shows why she shouldn't be going behind it. And again, it underlines the unreality of reaching a different conclusion as to what was said from the conclusion reached by Mr. Jarvis, who was there. and paragraph 68 goes on to make the same error in my submission, or the same set of errors which I've already addressed. I'll just adopt my previous submissions in relation to that. Paragraph 69, she addressed my submission that even if paragraph 130 of the judgment was inaccurate, it should have been corrected by the parties. I do stand by that submission. It goes both to the probabilities. If it had been wrong, someone would have corrected it. This was a very important point for everyone in court. Leading counsel was there for Iftikhar, counsel was there for the trustee. If the judge had got something like this wrong, someone would have corrected it. It also is a point of principle because Zacaroli didn't correct it. My submission, his sitting by and letting it go through, should be fatal for him in the same way that it was in the Gandhi case, for example. So the judge was wrong to reject that submission, and paragraphs 70 to 73 then set out her conclusions, and I have really made each of the submissions that I make to criticise what those conclusions are. Those paragraphs display in my submission each of the 4 quick vices on which I've made submissions. So in my submission, that was wrong, and what she should have done is not gone down that road at all and left us with the conclusion of someone Judge Gerald, or if she was to reopen it, should have arrived at the same conclusion, which is an inescapable one on the factual findings that she had and on said by Mr. Jarvis. So that is what I have to say on that point. As I said a few minutes ago, I don't propose to address the 4 shorter respondents' notice points now. I'll say anything I need to say about them in reply once they've been opened, as far as they're opened. What I propose to do with the remaining time between now and lunch is make the adverse possession point. That comes under 2 headings. Both are concerned with animus possidendi, or the intention part. The first part is that the point that Zacaroli was at all times asking Iftikhar to pay the service charges throughout the relevant history. That's the point on which Iftikhar succeeded before His Honour Judge Gerald. And in relation to that, I'm seeking to go back to what the judge held at first instance. The second point is about the fact that Zacaroli was saying at relevant times, not that he was in possession in his own name for his own benefit, but that he was occupying by permission of or by arrangement with, I say as a licensee of, the alleged family partnership, or subsequently of his father when he started saying his father was the true, which is another possessory intention point. The first of those points is section A in both party skeletons, the second is section B. Starting with first principles, which are the same first principles for both points, the test for adverse possession comes in 2 parts. First, physical possession. Second, intention to possess on the party's own behalf and for his own benefit. That second limb should not be equated with an intention to own, it's an intention to possess. It is also true that it will often be found satisfied in the same cases where factual possession is shown, but that doesn't mean it always will, or that it's a dead letter. As Zacaroli's submissions, and in my respectful submission, Mrs. Justice Bacon's judgment risk making it. It's clear in all the authorities is there as an important second limb. If we could look briefly at Powell, which is the first of the 2 key authorities on the principles. That's authorities tab 1, sorry, bundle 1, tab 6. This is a decision of Mr. Justice Slade, very well-known one in the field, which continues to be important. Effectively, it's endorsed as a masterful judgment, a right in Pine Graham. It concerned a field belonging to the defendant, which had been vacant, and the claimant had been making various use of it over the years. The relevant passage on the law, which is the classic passage, is page 470 to 471. Which is the sidebar bit down at the bottom.
I'm sorry, I got distracted by
I'm so
the cow
sorry.
on the land in the head note.
Yes. As so often in these adverse possession cases, the facts are strikingly agricultural.
So where am I supposed to be reading as opposed to where I was?
Well, it was page 470.
Thank you. Yes, thank you.
Numbered 2 towards the bottom of the page. If the law to attribute possession of land to a person who established no paper title, he must be shown to have both factual possession and the requisite intention to possess animus possidendi. And 3 explains that factual possession signifies appropriate degree of physical control. Various other things are said about it. Then on the facing page of 471, one gets the analysis of animus possidendi. And there's some discussion of earlier formulation of the then master of the rolls in an earlier case. And then towards the bottom of the page, in the last sentence, that's the key bit, what is really meant in my judgment is that the animus possidendi involves the intention in one's own name and on one's own behalf to exclude the world at large, including the owner with the paper title, if he be not himself the possessor, so far as is reasonably practicable, and so far as the processes of the law will allow. So that's taking the point that the fact that the adverse possessor accepts that if the true owner had come along and lawfully thrown him out, he would have gone, doesn't negate the fact that he was in possession until lawfully thrown out. That's not material to our circumstances. But I do stress the words in one's own name and on one's own behalf, which is a part of that classic formulation. And then over the page, he explains that animus possidendi is important in the case before him, and he explains that the owner or other person with the right to possession is readily assumed to have intention to possess unless the contrary is proved. So the slightest acts are enough. The position was quite different from a case where the question is whether a trespasser has acquired possession. In such a situation, the court, in my judgment, require clear and affirmative evidence that the trespasser claiming he's acquired possession not only had the requisite intention to possess, but made such intention clear to the world. If his acts are open to more than one interpretation, and he's not made it perfectly plain to the world at large by his actions that he is intended to exclude the owner as best he can, the courts will treat him as not having the requisite animus possidendi. And again, I say that's important. That applies to all parts of the intent, including the intent to possess for your own benefit and on your own behalf, in your own name. And then if you skip on to page 476, that comes back to animus possidendi. He starts with the need for compelling evidence for a trespasser to establish it. He goes on in the passage my learned friend took you to yesterday to explain that once you have possession, you have rights against third parties to exclude subsequent trespassers and obtain possession from subsequent trespassers. And then down in the next paragraph, he says, he refers to reluctance to find previous cases, and then adds a further observation that past or present declarations as to intentions made by a person claiming to have possession of land on a particular date may provide compelling evidence he didn't have the requisite animus possidendi. That may be relevant in this case, where one's looking at a range of statements Vacar made over a period of time, where he's saying at different times the basis of his possession is different things. But that what people say as the basis of their position normally can't be counted on in their favour, because it's generally self-serving. On the facts of that case, without going into the detail of what cow was where and when, animus possidendi wasn't made out. So it's an example of a case that turns on that, among other things. Pye and Graham then, if the incumbent on me to show you, it's tab 24. This is the House of Lords giving the leading judgment on adverse possession as it was, as it still is for such unregistered land as remains, and for the few remaining cases which exist under the old law for registered land. So proceeding into the past for many other purposes for registered land. This was a case of the claimant continuing occupation of land after the expiry of a grazing agreement under which they'd originally been in occupation. And again, the facts perhaps don't require a lot of attention. if you go to page 432, paragraph 31, you see the point that the statutory provisions can rise considerable difficulties, and there's discomfort at remarks made by the Court of Appeal in the case of Lee and Jack and Littledale and Liverpool, and then a strong endorsement of the remarkable judgment of first instance, Powell and McFarlane, in which Mr. Justice Slade traced his way through a number of Court of Appeal judgments which were binding on him so as to restore a degree of order to the subject. And although there are one or two minor points on which, unlike Mr. Justice Slade, your Lordship is not bound by authority and can therefore make necessary adjustments, for the most part, the principle set out by Slade J, as subsequently approved by the Court of Appeal, cannot be improved upon. So that's why I've taken you to Powell as well, because Powell gets the gold star treatment from the House of Lords, if I can say that with all due deference to Mr. Justice Slade, as he then was. Paragraphs 32 to 39 go on at some length to dispense with the idea that adverse possession needs to be reversed in the sense of contrary to the particular plans of the paper title owner. That's said to be a wrongful resurrection of old long ideas which have been long dead under the statutory regime, ouster and disseisin. For our purposes, one will go on to paragraph 40, which endorses the two-part test set out in Powell. And then in the body of paragraph 40, as one goes down, one comes to a submission made by Mr. Lewison, as he then was, that there was no need in order to show possession in law to show separately intention to possess. So it was being advanced in that case that in fact factual possession was enough. And that was rejected in very clear terms, in strong terms, by the House of Lords. No doubt that there are two separate elements in legal possession. So far as English law is concerned, intention as a separate element is obviously necessary. It's been the law since forever, and also makes sense. And examples are given by Lord Brown Wilkinson there. Case where A is found in occupation of a locked house. He may be there as a squatter, an overnight trespasser, or a friend looking after the house of the paper owner during an absence on holiday. Doubtless there are other explanations one could give as well, but those are the three examples that my Lord Brown Wilkinson picks out. So the acts done by A don't tell you whether he's there and whether there's legal possession. If A is there as a squatter, he intends to stay as long as he can for his own benefit. His intention is intention to possess. If he only intends to trespass for a night, or is expressly agreed to look after the house for his friend, he doesn't have possession. He has physical possession, he's got the key and he's locked the door, but he doesn't have the intention to possess. So one sees the continuing life and importance of the animus possidendi there in Lord Brown Wilkinson's examples. It's not the nature of the acts which A does, but the intention with which he does them which demonstrates whether or not he is in possession.
But, as Lord Hutton pointed out, the nature of the acts might themselves establish beyond any doubt the intention. For example, if you change the box.
Well, taking that in two parts, the nature of the acts, of course, will be relevant, will be part of the material from which one seeks to establish what the intent was in any given case. That's apparent from the way in which Mr. Justice Slade formulates the principle as well. And of course, there may be cases in which the nature of those acts, when you look at all the acts together, puts the point beyond doubt. So thus far, I'm in complete agreement. But equally, one has to look at all the acts and say, when one looks at all these acts, is the position unequivocal, which is what's required? Does it make it absolutely clear to the world at large that all of the elements of intent to possess are met, including to possess in your own name and for your own benefit? As to the changing of the locks, well, one can imagine a case where the changing of the locks in the factual matrix of that case will make the position clear. But it can't be the case, and in my submission, Lord Hutton can't be read as saying, that in every case the changing of a lock will make the position clear. Indeed, in any of Lord Brown Wilkinson's examples, there could be a changing of the lock. Paragraph 41 deals with factual possession. Paragraphs 42 to 43 then deal again with intention to possess. And the point's made that it's not an intention to own, it's an intention to possess, with which obviously I don't quibble. And the paragraph ends at the end of 42, the end of 43, with an endorsement of Mr. Justice Slade's formulation, which we looked at in Powell, an intention in one's own name and on one's own behalf, which obviously I stress, to exclude the world at large, etc., etc. So one needs, looking at those authorities, an intention made clear to the world, which is unequivocal, that he intends to exclude the world at large, including the owner, on his own behalf for his own benefit. Now, if one has the relevant findings, then Mr. Justice Gerald, 417. Start on page 234. I'm so sorry, 243. Paragraphs 104 to 108 contain, in my submission, orthodox and correct statements as to the law, based on what we just looked at. The correct test for animus possidendi is set out, the burden of proof is established. Then there are set out the facts concerning Vacar's request for Iftikhar to pay the service charges from 1987 onwards. That's paragraphs 109 to 113. And what one can see from that, without taking through it paragraph by paragraph, because I know you've already read it, is that Vacar asked Iftikhar to pay the service charge and Iftikhar paid them. And in my submission, before one gets to any further authority, one can make the basic submission that such conduct is plainly at least equivocal to the world at large as to whether Vacar is occupying to the exclusion of Iftikhar for his own benefit and on his own behalf. And the judge's conclusions are then set out in paragraphs 114 to 119. Why did Mrs. Justice Bacon not follow that? The point which impressed her was that the legal obligation to pay service charges under a lease is one which falls on the paper title owner as the tenant under the lease, and that a person who is merely in possession of the leasehold land, e.g. as a trespasser, has no legal relationship with the lessor, and so no legal obligation to pay the service charges. For that reason, she said that payment of the service charges is not an incident of possession. It's not a legal obligation which falls by virtue of possession. It's a legal obligation which falls by virtue of being the tenant under the lease. Now, it is correct that payment of service charges is the legal liability of the tenant under the lease, not the legal liability of a possessor. I don't dispute that. And in my submission, His Honour Judge Gerald wouldn't have disputed it either, but it's a point which goes nowhere, because an occupier can perfectly well render their intentions equivocal by doing or by not doing all sorts of things, whether or not they are things that they are under a legal obligation to do. Looking at the Graham Wilkinson's examples in Pi, a trespasser who's taken physical possession of a locked house, has the key, but only intends to stay there overnight, lacks animus possidendi because they don't intend to stay for the longer term. They're not legally obliged to stay for the longer term. It's not a legal obligation of possession to be in the property, but that lack of intention is enough to negate the possessory intent. Another example, the occupier who's in control of the locked house to look after it for the paper title owner lacks animus possidendi because they're reporting back to the paper title owner. and conceive themselves as doing it, represent themselves as doing it on behalf of the paper title owner. And they intend to return the keys to them in due course, presumably. But that's not because a person in possession of land is under an obligation to return a key. The question of whether there's a legal obligation to do the thing is not the start or the end of the analysis. The start and the end of the analysis is, what does this act tell you about what the person in occupation is communicating to the world about the nature of their occupation, the basis for their possession. And one can see, to take another example, perhaps a trivial example, a person in possession of a dwelling house is under no obligation by reason of their possession to stop the roof falling in and the house becoming unpleasant for that reason. But it is naturally to be expected that that person will do that as a matter of practice if they wish to maintain their possession, because otherwise their possession will become untenable. They'll be trying to hang on to a house with no roof. So if they ask the paper title owner, will you please come in and mend the roof for me, that does render equivocal whether they are really intending to possess on their own behalf or on behalf of the paper title owner. And that's not got anything to do with whose legal obligation it is to mend the roof. In that case, no one has a legal obligation to mend the roof. There's no legal obligation not to let your own roof fall down. It's to do with, is this something that a person in practice, a person possessing on their own behalf, would in practice be expected to do? And I say it's the same in relation to the occupier of a leasehold flat. The trespasser isn't under a legal obligation to pay the service charges to the lessor, but the payment of those service charges is an obvious practical necessity if their occupation is to be maintained. Because otherwise the lessor will come and turn them out, turn everybody out. And so in that sense, in the same way as mending...
Turn them out as the lessor, because they're not liable for the service charge. It may be turned out for different reasons, but it won't be for not paying the service charge, because they're not liable for it. The continuance of the lease might be in jeopardy.
Yes, I've elided a couple of steps, as my lady rightly picks me up on. If the service charge does not get paid, in practice what will happen is a chain of events will follow, which will result in the lessor bringing the lease to an end and resuming possession of the flat. And at that point, the occupier will be turned out. So my lady's absolutely right. It's a sequence of legal steps would have to happen. The point of my submission is
The end result would be...
the end result will be that. So it's analogous to mending the roof, or doing anything else that one would expect someone to do if in practice they want to be able to maintain possession of this property, or mending a fence, or whatever it may be. It's not about legal obligation, it's about you need to do it in reality if you're going to carry on in possession. At that moment, I probably ought to look at Pavlidis, which is a case in this territory and is the case that was cited by Judge Gerald in paragraph 115 and was explained differently by Mrs. Justice Bacon. That is Authorities Bundle 1, tab 8. Now, to put it in context, this is a case decided before Pye and Graham, but after Powell. It is applying principles in Powell. So in my submission, there's no sense that it's old law or outdated, because the principles subsequently endorsed by the House of Lords were already established by Powell and they're followed here. And indeed, I believe Pavlidis was cited in argument for the House of Lords in Pye and Graham, without anything being said about it. By way of disapproval or I think otherwise. It was about occupation of a patch of land next to a factory. The plaintiff was the lessee of the factory. He'd been using the land as a car park and claimed adverse possession on that basis. The claim failed on several grounds, one of which was a lack of animus possidendi, because the claimant had periodically asked the paper title owner to mend the fence of the property to keep out trespassers. And if you go to page 465, you see a factual finding to that effect, which is the sidebar passage on forms 5. So there's an account there of what occurred, which includes that Mr. Pavlidis, the claimant, had been complaining to the GLC, the paper title owner, about the fence and wanting it repaired. That was indeed his own evidence. He says that's a fact which I must return to in connection with these claims to have been in adverse possession. Then if you go on to page 478, well, here one sees the bottom of 478 and over the successive pages that the judge, Mr. Justice Knox, was applying Powell. He's applying the correct principles. Then on page 480, he gets his conclusions. In the middle of the page, he deals with factual possession, where he finds there's a problem with the claim. And then at the foot of the page, he starts on the mental element. And what he says is that, as far as the mental element is concerned, in my judgment, Mr. Pavlidis can't be heard to claim he was in adverse possession as against the GLC in respect of periods when from time to time he actually called on the GLC to do its duty as the person entitled to possession to keep out trespassers. That's quite a separate question from the one where there's acknowledgement to, such as to start time running afresh. Possession is indivisible. It seems to me that Mr. Pavlidis cannot validly claim himself to be in adverse possession as against persons whom he actively requested to shoulder the responsibilities that possession has. Mr. Alders sought to meet this point by distinguishing acts of enjoyment, such as taking crops on the one hand and discharging responsibilities on the other. In the former, he accepts a person with paper title who uses the land beneficially cannot be treated as dispossessed. It's obviously right if there's someone taking crops or taking rent from the land still, then they are in possession, at least the relevant title, by virtue of doing that. Nor can the trespasser be treated as being in adverse possession. But in the latter case, he claimed that he could. I don't see the logic in the distinction, nor do I consider that this view of the matter involves elevating verbal acknowledgement. And then he deals with the acknowledgement point. The field of acknowledgements is far wider than the type of activity which I have in mind. That's to say, requests to the owner of a paper title to discharge the responsibilities attached to possession, which here he's regarding as relevant not as acknowledgement, but as rendering at least insufficiently unequivocal the possessory intent as communicated to the world. And when he talks there about the GLC doing its duty as the person entitled to possession and the GLC shouldering the responsibilities that possession has, in my submission it's clear that he's not talking about legal obligations, because the person in possession of land isn't under an obligation to keep the fence in repair or to do anything else. What he's talking about is an obligation or a duty in the practical sense of something that a possessor of land must do to, or would be expected to do, to retain their possession. You're not obliged to keep the fence. The problem is if you don't maintain the fence, you're at risk that someone else is going to come in and take your land. And you'll lose possession. Equally, you're not obliged to pay the service charges, but if you don't, the problem is you're at risk that someone else is going to come, maybe the lessor, take the flat. For that reason, it's an incident of possession. It's a characteristic of possession, in that it is something that you would expect the possessor of land to do, not that it's something they're obliged to do. Now, Mr. Justice Bacon's explanation of the Pavlidis case was that because it was about maintaining a fence, it showed that the squatter was not maintaining physical custody and control over the property as against the paper title owner. That was her basis for setting it to one side, that it was about physical custody and control, whereas this was not. And one takes that from paragraph 99 of her judgment, so paragraphs 103 to 105. What she's saying there is, well, Pavlidis is not on point because it's about possession requiring the possessor to exercise physical control and custody by excluding the world at large. So requesting someone to do that is inconsistent, different from the present case where the request was to defray an obligation of ownership and nothing to do with physical custody and control. Well, that's not right for a start because it's not what Mr. Justice Knox said, and it's not reflecting anything that is a distinction of principle set out in Powell or in Pye. It also, in my submission, doesn't work as a matter of logic. The fact that the squatter in Pavlidis was inviting the paper title owner onto the land to do work wasn't in itself inconsistent with the squatter asserting possession. The fact the squatter invites the paper title owner on could be said to be consistent with possession if the premise of it is, well, I'm the possessor and you need my invitation to enter. It's not the fact that they're letting the paper title owner onto the land that negates their intention to possess, given they're doing it at their invitation. The true significance is they're asking the paper title owner to do an act which is characteristic of possession. And in my submission, payment of service charge is in the same category. And that really is the gist of the point. We say that what was happening was that Vacar was actively asking Iftikhar to shore up his ability to stay in occupation by taking the key step of paying service charges. And we say that renders it, at least, that's all that we need, beyond being unequivocal, that he was intending to possess on his own behalf, in his own name, for his own benefit. In my submission, that's an orthodox application of Powell and Pye. It's exactly parallel to the position in Pavlidis, which is another orthodox application of those principles. His Honour Judge Gerald was right to reach that conclusion, and Mrs. Justice Bacon was wrong to overturn it. There are some other cases cited in relation to this point. I'm not sure any of them are central, and I won't turn them up. To explain, there are two foreign authorities cited, a Northern Ireland case, St Patrick's Archdiocesan Trust, tab 42, and a Hong Kong case, Hollywood Shopping Centre, paragraph tab 32 of the authorities bundle. The point of those cases isn't that the facts are particularly close to these. They're not in either case closer to ours than Pavlidis, for example. But they are cases which cite and apply the principle in Pavlidis. So I cite them partly to head off any suggestion that Pavlidis is a sort of case out on the lid or a flash in the pan type case. It's a case that's being followed and respected and applied in other parts of the Commonwealth. We also cite Pekin and Pekin, which is tab 3, simply as an example of a case where payment of rent by the paper title owner was relevant as part of the factual assessment of whether there was possession in that case. But again, I'm not sure I need to turn it up. What one comes back to is the judgment of Mrs. Justice Bacon from paragraphs 89 onwards. Mrs. Justice Bacon considered that His Honour Judge Gerald was proceeding on the mistaken basis that payment of service charges was an incident of possession in the sense of a legal obligation. In my submission, that's not a fair reading of His Honour Judge Gerald's judgment. In my submission, he was in fact talking about instance of possession in the same sense as responsibilities in Pavlidis, practical things you need to do rather than legal obligations. And the remainder of Mrs. Justice Bacon's judgment turns upon the point I've addressed, which is the lack of a legal obligation to pay the service charge. Paragraph 97 refers to the fact that Vacar was in physical possession if Iftikhar was excluded. But that's obviously right. And of course, it's the point that my learned friend makes and emphasises and with his customary eloquence bangs the drum about. But in my submission, that's the beginning of the question, not the end of it. The fact that you're in the room, you're in the locked house and you've got the key is the beginning of the inquiry as to intention to possess, not the end of it. And as I've submitted, paragraphs 98 and following, she then distinguishes the Pavlidis line of authority and deals with the submission I've just been making, and in my submission wrongly so. So that is that ground of appeal, the first of the adverse possession points. The second of the adverse possession points is a point which was raised by way of respondent's notice before Mrs. Justice Bacon and was not accepted by her, and I seek to renew it now. It was dealt with very shortly in her judgment. It's paragraphs 130 to 132. It's worth turning those up swiftly. I'm so sorry, turning them up briefly. It's not for me to tell the court whether to do it swiftly or otherwise. And she dealt with it there. She was dealing with several related points, some of which I'm not pursuing, but also this one, which I am pursuing. And the analysis that she adopts there is related to the question of whether Vacar thought he was occupying as a licensee. And so Mr. Justice Bacon takes a short route through the point. She says, we know he didn't think he was occupying as a licensee because of His Honour Judge Gerald's findings that in his own private mind, he thought he had a claim, even if he was hiding it from the trustee and so forth. But that isn't the right way to approach the point, because it's not about Vacar's private mind. This is about Vacar's words and actions to the world at large, and whether they communicated a clear objective manifestation of an intention to possess for his own benefit. That submission isn't dealt with in terms by Mrs. Justice Bacon, though it was one that was made. The transcript's in the bundle if you need it, at page 247 of the supplemental bundle. It arises from the facts, which is that over the period of time in question, Vacar, while his position as to his basis of his occupation in the flat was shifting and less than clear, insofar as there was a clear position adopted as to what his basis of occupation was, it was by right of someone else letting him be there. Absent formal tenancy, an informal arrangement that someone else was letting him be there, which we would say is rightly characterised as a licence. The relevant findings on that, the period from 1987 onwards, are in His Honour Judge Gerald's judgment at paragraphs 31 to 32, and then at 81. Those are page 229, the first spot behind tab 17. One gets a 31 to 32, a summary of Vacar's firm position in 1987, that the flat was owned beneficially by a family company or partnership. To be the residence of the family member resident in London, which was him. And that was the basis of his right of occupation, as distinct from ownership. Elsewhere it was allocated to him. And then in paragraph 32, you see position 1987, he had a mere right of occupation again. And if one moves on then to paragraph 81 on page 239, one sees again in July 1987, it was Vacar's evidence of case. He had beneficial interest in a license to occupy by reason of being held on trust for the partnership with his partners and the three brothers who were all sued. So my submission, the position in 1987 was either I am a licensee of the family partnership, or it was simply opaque. But simply opaque doesn't assist.
I also say what, because if he genuinely did think he was occupying under a license from, let's start with a license from the actual owner.
Yes.
That's been held not to be a bar, hasn't it, to a claim in adverse possession at the Court of Appeal in Pye itself, I think. Or actually, it was Lady Justice Arden, wasn't it, in the case we looked at yesterday?
Oh, my lord, that's an important point. It's probably the point which will take the remainder of the time till lunch.
Okay.
The short answer is that case is about someone who thinks they're a tenant.
So it's all the difference between tenancy and license?
My lord, yes, because that's inherent to being the tenant is that you have possession. That's Street and Mountford, and the three-pronged implement for digging is a is a fork, even if it's described as a shovel. Says if you think you're a tenant, it's inherent in thinking you're a tenant that you think you've got possession, not so a license. And that point of law, my learned friend says the right view is that the same should follow for a licensee. My submission is the same shouldn't follow for a licensee, because why should it? The licensee is in occupation not pursuant to a right to possession, but on behalf of, as a representative of the person who grants them the license. And that's a question which is subject to conflicting first instance authority. And there are, I think, two my way, which are first in time. There's one Malone Friends way, and there's one which prefers Malone Friends view, but pops up without all the previous cases. I'm going to turn to that in just one moment. Just before I do, the only other thing I'll say is that was his position in 1987. That's what he was communicating to the world at large. He was putting in affidavits to the court, which is hard to imagine a more clear form of broadcasting. By 2011, what he was saying was something somewhat different. By this time, he was bankrupt, and what he was now saying was the property belonged to his father. So at that time, his case, as your ladyship and your lordship will recall, his position was, well, the settlement agreement within the family, or the dispute resolution process within the family, involves the father becoming the owner, deciding what's to happen to it. And that's why he was telling his trustee, well, this belongs to my father, it's nothing to do with me. I don't own it. And that's dealt with in paragraphs 89 to 93 of the general judgment, which we've looked at sometimes, so I won't turn back to them now. So exactly who he was saying owned it was different, but even by that time, by 2011, his position was still, I'm there because the true owner's letting me there, which was his father, by that time, is letting me be there, pending the final resolution of all of the family dispute and it being handed over to me.
But there's a finding that he did not have that intention, of which you don't challenge, is that correct?
Correct.
So this is based solely on, even though he did not have that intention, you say there's an additional requirement that he not only must have the intention, but also manifest it to the world at large.
Correct.
But isn't the manifestation to the world at large part of the question whether he in fact has the intention? Because the court doesn't trust subjective statements.
My lord, no. In my submission, the passage I've cited from Powell and Pye, this question is an objective one.
And it's an additional question to having the intention on your case.
I'm not sure what the position would be, and it doesn't arise in this case, if you had a situation where the possessor clearly and objectively communicated to the world that he had an intention to possess, but in his own private mind didn't.
Well,
that might be an interesting question for another case.
The court has found, on an objective basis, as looking at the evidence as a whole, has determined that he did not have the intention to possess as licensee. Not just because he said that, it's the court's conclusion. He said the opposite, but the court comes to that conclusion.
Well, that is with, my lord, that is with the benefit of having cross-examined him. That's a conclusion which the court can reach in 2020, having cross-examined him as to what his true intentions were, and having established that he had true intentions which were different from what he was communicating to the world at large.
Yeah, so it is an additional requirement, notwithstanding the court having found, on the basis of all the evidence, not just his say-so, that he did not have the intention. You say that doesn't matter. He's got to also have manifested to the world the same thing.
My lord, yes.
Yeah.
Well, it's either an additional requirement or possibly it's the only requirement. I'm not sure I need to firmly take a view as to whether it's an additional requirement or the only requirement. But the passages we've looked at in Powell and in Pye make clear that the question of intention is to be looked at objectively in terms of what's manifested to the world. So the fact that he had a different intention in his own private mind, as we now know, doesn't answer the question. Because that finding is not based on the outward statements, it's based on what we now know about his private intentions, which he was disingenuously not communicating.
What about someone who manifests to some of the world one thing, but to some other part of the world another thing?
Well, my lord, I think in that scenario one would say it's the world at large that matters. I would
Which
cleave
half of the world at large?
Well, if one's communicating publicly to most people, I don't have the intention, and you tell your spouse or your friend in your study that actually you do, then in that scenario, it's the world at large. It's the larger part. If, the example my lady poses, one has a situation where somehow one is communicating one thing half and half. In my submission of that scenario, one would say, well, it's equivocal. One's not communicating it to the world at large. One's only communicating it to half the world. One's communicating something different to the rest of the world. And one has created an equivocal position. And applying what's said in Powell and Pye, that wouldn't be good enough. But that example, testing as it is factually along with where we are in this case.
Thank you.
Okay. So that takes one to the law. The short position here is that there is a run of cases. It starts with the necessary background is a case called Say and Kung, which is
Well, how are we going to tackle this, given that you've got 7 minutes?
what I'm proposing to do is to show you Say and Kung, to
Yes.
show you Lambeth and Rumbelow, so two
All right.
authorities.
Sure.
I'm then proposing to make the submission, which I think will be common ground, that Clowes goes the same way as Rumbelow, albeit without it being cited. When a friend says it's wrong, I say it's right. And I'm then going to make the submission that the subsequent cases which go my learned friend's way, one can deal with the simple submission that they don't properly deal with the law that was established before.
Give us the paragraph numbers in your skeleton argument where this part is dealt with, please.
My lady, yes.
Just so that we, even though you're truncating it, we're cross-referencing it to your...
I'm very grateful for the accommodation. That is in the supplemental bundle. This topic as a whole is
41 to 45.
Yeah.
yes, I think
Sorry, that's not your skeleton, sorry.
my lord is absolutely right. It's 41 to 45.
Thank you.
I'm so sorry, 39 to 45. I think I misspoke.
Sorry, the other side skeleton.
So we've got your analysis of the two divergent authorities there.
And lady, you have, and it may be on that basis that I don't need to take you, in fact, to any of the cases that are summarised there, because I've said what I have to say about all of them.
You have, obviously, we'll go and read the case, we'll go back to the actual cases.
I'm grateful, and in my submission, that what's really happened here is that Rumbelow, which is the first in the line and is a judgment of Mr. Justice Etherton,
Yes.
gets it right. And if it had been reported, everyone would have been saved a lot of trouble. The problem is no one in any of the subsequent cases seems to know about it. Indeed, if it had been, then Mr. Justice Hart would have been following that in Clowes. And his reasoning would have been all the stronger for it. And in that situation, when Mr. Justice Davis Richards looked at the case of Wretham and Ross, he'd have had two very compelling trial judgments going the same way on correct analysis, and one wouldn't have this divergence. The one case I will show the court, if I may, conscious I have less than 5 minutes, because it's not in this run, is Say and Kung.
Of course.
Just because there is an important point that emerges from that one needs to have in mind before one turns to that run of authorities. That is part 12 of the authorities bundle. It's a decision of the Privy Council on appeal from Hong Kong. The plaintiff was the registered owner of the land in question. The defendant had gone into occupation.
And tab 12, did you say?
Tab 12.
Thank you.
For part of the period of the defendant's obligation, occupation, the defendant had been in receipt of a licence to occupy. granted not by the owner but by the Crown under a Crown land permit, which had seemingly been granted by the Crown in ignorance of the true ownership. And Privy Council held, as between the plaintiff and the defendant, there was an arguable adverse possession defence, because the defendant could add up the periods when he'd been in possession on his own behalf with those where he'd been in possession on behalf of the Crown. But the significance for our purposes is the passage on page 1, 2, 3, 5. In the first chunk of the sidebar passage, and then just after and start the next paragraph, where it is absolutely clear that the principle is, as endorsed by the Privy Council here, that for the purpose where he is off, the period where he has the licence from the Crown, the effect is that his possession is on behalf of the Crown. For the purpose of limitation, therefore, possession from 1961 must be regarded as having been in the Crown, which possessed through its licensee, the defendant. And that is important just to help with my answer to my Lord Justice Zacaroli's question about why is this different from a tenancy. Tenant and the licensee are in fundamentally different positions, and that is so, to use my final minute, that is so whether the licence is a temporary licence or is a non-temporary licence, which is not immediately revocable. And indeed, among the cases that are cited, one can see on the facts of Rumbelow. Rumbelow is a case where the licence which had been asserted by the possessor could not have been one that was said to be an instantly revocable one, because the licence had been asserted in a letter sent to the paper title owner to stave off possession proceedings. The letter said, well, I've got a licence, don't come and throw me out. Obviously, that wouldn't have been of any use if the licence that was being asserted was an instantly revocable one. So I say that's an illustration of why my learned friend is wrong to, as I apprehend he will, say that even if the position may be as I submit for some types of licensee, that is only for licensees whose licence is revocable. I say not so, there's no reason to draw that distinction in principle. And one can see from saying Kung, and particularly from Rumbelow, the position must be the same where the licence is not simply revocable. So if the court will indulge me with one moment to turn around,
Of course.
I apprehend that those will be my submissions. I'm very grateful indeed.
No, thank you very much indeed. That's moved up. Very well. 2 o'clock, please.
Oh, where's the table?
So